We drum in that messaging around the dangers of COVID pretty diligently for a full 2-week period of sustained propaganda.
Now, please be seated. The district court is now open. Calling the matter, Joden Finance versus Prersslip.
Thank you. Now I got Mr. Murphy.
John Murphy.
Just come forward, Mr. Murphy, please. It's Miss
Furiava, sir. Thank you, sir. So I wonder if I might request that Mr. Prersslip be seated next to me, sir. He's rather hard of hearing.
Oh yes, he can do that.
Thank you, sir.
Right, well, Mr. Murphy, I have your submission. Did you want to address that?
Yes, Your Honour. Have you read the submissions?
Yes, I have.
I would just like to refer to the relevant facts in those submissions, and those are the previous decisions made by the Auckland branch of the Motor Vehicle Dealers Tribunal.
Who made those decisions?
By Mr. Brett Carter.
Were they all made by him?
One was made by the other adjudicator in the tribunal, but it was an Auckland hearing.
Sorry, Ms. Furiava, I just haven't had time to check this, but the decisions that Mr. Murphy refers to, are they in your bundle of documents?
They are, sir.
Mitchell and Trading Post, I see.
They should be at tab 8, 9 and 10, sir. And I believe they are all decisions of the adjudicator Carter, sir.
They're all Mr. Carter's?
Correct, sir. That's what I believe.
Yes, all right, thank you. All right, well, Mr. Murphy, I understand your argument, and that is that Section 21C of the Act is expressed in mandatory terms, where it provides that if the vehicle is damaged while in the possession of the purchaser, the right of rejection is lost. That's your position, isn't it?
Yes, and I'd also like to refer to the Wright versus Fortis case, Your Honour, whereby that person lost the right to reject after having the vehicle damaged and after having that vehicle repaired to the highest trade practices.
What part of that decision do you refer to?
Section 20. I'm inclined to agree with Mrs. Wright that she would have been entitled to reject the vehicle because of its failure to comply with description for the purposes of Section 21B of the Consumer Guarantees Act. The vehicle departs in significant respect from its decision and its description. However, Mrs. Wright has lost the right to reject the vehicle because it was damaged while it was in her possession. Section 20 of the Consumer Guarantees Act sets out the circumstances in which a purchaser loses the right to reject the vehicle. That clause, Your Honour, is Section 21C of the CGA, whereby Mr. Carter was satisfied that the vehicle had been damaged since it was sold to Mrs. Mitchell. The vehicle had minor damage to its front bumper, but it was still rejected on the fact that the car had been repaired and she had lost the right to reject the goods. And the accident was whereby she was having the car serviced by Home Tune. The employee of Home Tune reversed into the vehicle, damaging the right front of the vehicle. Mrs. Wright advises that the damage was minor and mostly to the front bumper and has since been repaired by a panel beater. Although the damage has been easily and inexpensively rectified, Mr. Carter was satisfied for the purposes of Section 21C of the CGA. Mrs. Wright has lost the right to reject the vehicle. The vehicle was damaged after delivery to Mrs. Wright for reasons not related to the state or condition at the time of supply. The subsequent repair of the damage does not re-establish Mrs. Wright's right to reject the vehicle. I consider that Section 21C of the Consumer Guarantees Act is clear and the right to reject the vehicle is inadvertently lost when damage occurs. And there's no suggestion in the CGA that the right to reject can then be resurrected if the damage is repaired. Accordingly, Section 20C of the Consumer Guarantees Act, Mrs. Wright has lost the right to reject the vehicle. Her application to reject the vehicle under the Consumer Guarantees Act must therefore be dismissed. Mrs. Wright will undoubtedly consider this aspect of the decision to be harsh, given the relatively minor damage compared to the value of the vehicle. However, I have no discretion under Section 21C of the CGA once I am satisfied that the vehicle has been damaged while in Mrs. Wright's possession. I have no option but to conclude that she has lost the right to reject the vehicle.
Yes, all right. No, I'm not bound by that decision, am I? Decision of the Motor Vehicle Disputes Tribunal, or any of the other decisions of that tribunal for that matter.
The tribunal also, Your Honour, mentioned that.
Well, do you agree with that, Mr. Murphy?
Sorry, Your Honour, I was under the impression that the tribunal's decision, in an expert tribunal, was a decision that held fairly steadfast in legislation that was made by Parliament.
Well, it's appointed to resolve disputes relating to vehicles, but it's a lesser tribunal than this court. So the basic rule is that decisions of lower courts or tribunals don't bind courts of higher jurisdiction. It's a simple equation, essentially. The High Court binds this court, the Court of Appeal binds the High Court and this court, and so on. So I just want it clear that this court's not bound by decisions of the Motor Vehicle Disputes Tribunal, and in particular it seems that these three decisions are by the same adjudicator, and he's been consistent. That's fair enough, that's appropriate. So is it your case that even although there is a right to reject a vehicle because it is not of appropriate quality, if the slightest damage occurs to that vehicle, the right of rejection is lost?
Okay, so you just heard Gary basically knocking the shit that a lesser tribunal district court doesn't have to give a fuck about what a lesser court cares, but the facts remain the same. The tribunal's interpretation of the legislation is correct. Nowhere in that legislation you'll notice does the word slight, mild, minor occur. It's simply damage. And you watch later on, old Gary, who's been around since the Erebus disaster, decides to start asking John what his interpretation of damage is. John, being a layman, he doesn't know the correct legal interpretation of damage. You would expect a judge of 40 years to clearly know, though. So why is he trying to find out what someone else's interpretation is when he's the one there, supposedly the one that can correctly interpret what legislation is saying? So you watch. He goes and starts hacking on John about the definition of damage, what it could mean, scuffing the old briefcase up against the side of the vehicle, that sort of thing. Bear in mind, in later clips that I'm going to be posting about this, I'm going to show you all of the slightest damage, and we're talking about guards being ripped up. This old geriatric prick that bought the car drove it up onto concrete berms, took chunks out of the wheels, out of the actual metal wheel, gouged out pieces of rubber out of the tyres, ripped off fucking bumpers. That's supposedly slightest damage. So, are you getting the point? See, Gary doesn't like John, and his bias reeks throughout this, and I don't really give a toss what Gary Michael Harrison thinks about me. I exercise my rights. If he's got a problem with that, he can fuck off somewhere else. But at the end of the day, these people are all trying to follow the law and stick to the law, and he's trying to muddy the waters, murk it up a bit, so there's a little bit of confusion. Nothing. I was there as a support person for John. John has a health condition. I was there to keep an eye on him and make sure it, tempers didn't flare. Anyway, moving on.
With the previous case law that I've looked at, and I have been relying on the expert tribunal, the Motor Vehicle Dealers Tribunal, and the relevant legislation of the Consumer Guarantees Act, particularly section 21C of the Consumer Guarantees Act, and Mitchell versus Trading Post, Poe versus Harvey.
Yes, I understand that. You're relying on those. What if Mr. Prersslip inadvertently sort of brushed this vehicle, let's say, with his briefcase, put a little scratch in the door. That can easily be repaired just by buffing it. It's gone. Do you say that robs him of his right of rejection?
Robs him of his rejection? What? Like, if you go and damage something, then all of a sudden, and damage it? Hear the word damage? Why does theft have to come into it? Why does robbery have to come into it, Gary? You know, it robs him of it? No, it's in his possession. He causes damage, then yes, right of rejection is lost. It's that fucking simple. Moving on.
In my view, Your Honour, and I don't want you to criticise me for it, but it would be absurd to interpret the rejection provisions of the Consumer Guarantees Act to include minor damage. It would open the floodgates to all manner of lucrative claims. You know, I've bought for instance, I had a flood in a rental property on the weekend. I recently had new carpet put down on it, which I didn't like. The carpet got wet. Is it fair that I asked them to replace the carpet? It would encourage this particular case, and I do know a lot of people in business, would encourage people to reject goods on an unlawful basis. Now,
but according to you, I don't follow that. According to you, they can't reject them if there's been the slightest bit of damage caused to them.
Yes, and particularly with an expensive piece of merchandise such as a Mercedes-Benz like this, I have a photograph of the damage, and I can assure you, Your Honour, it isn't a slight touch of a briefcase.
Well, I'm bound by the findings of fact of the tribunal, so I can't look at new evidence on
Not a problem, Your Honour.
appeal. And we've had an earlier hearing about whether or not you were going to call further evidence, and I think you made the decision not to, and that
I'm comfortable with that decision.
claimed that the decision of the tribunal was wrong in any event. Do you have any definitions of the word damage?
Now, the tribunal in this case are calling it ordinary wear and tear, is their wording in their decision. Now, in this case, it cannot be considered to include damaged. Ordinary wear and tear cannot include damage caused by an accident, which is caused by the owner having an accident through his carelessness or recklessness.
Or what about a scrape to the wheel? Forget the word. What is it?
Fair wear and tear.
The wheel hub.
You're calling that fair wear and tear?
No. Well, do you agree that's fair wear and tear?
Absolutely not. That's damage, Your Honour.
So,
That's caused by the negligence of the driver and the carelessness. And that's not ordinary fair wear and tear. I'd acknowledge a tyre wearing out after a specific period of time. Perhaps the brake pad's wearing out. But in this instance, we've got a gentleman who's, I don't want to upset the guy, but through carelessness or recklessness has hit the curb and significantly damaged the wheel and pulled the front bumper off.
well, that's not what the tribunal found.
The tribunal found, Your Honour, that it was ordinary wear and tear.
Yes, it did.
And my argument is that it's not ordinary wear and tear. It's caused by an accident which is attributed to the operator of the vehicle. And in my view, that alone entitles, disqualifies the gentleman, along with the decisions that have been made by the head, Mr. Brett Carter, the head of the Motor Vehicle Dealers Tribunal, the head of the Motor Vehicle Dealers Tribunal.
Well, I'm not bound by any of
Okay.
his decisions.
I understand that, Your Honour, but I have to come to this court with some form of legislation to back my appeal. I've got no other choice but to use these. And I will respect your decision, but...
Well, you see, you've got two. You've got this decision from Mr. McHerron, who's the adjudicator here, and he says, I am not satisfied that it is sufficient to amount to damage for the purposes of section 21C. Rather, I consider that this damage is likely to be able to be quickly and economically repaired, and is a type of minor damage that is consistent with the ordinary wear and tear of a vehicle of this age and mileage. Now, that's quite the converse of the earlier decision of Mr. Carter, where the lady had the vehicle repaired. As I understand it, there was no indication of any loss of value of the vehicle. But Mr. Carter has interpreted the relevant section as mandatory. And your submission is that if there's the slightest bit of damage, however caused, then that's it, the right of rejection's lost. Because that's your submission, isn't it?
Your Honour, we looked at the interpretation of the Consumer Guarantees Act, and with respect, Your Honour, we also looked at the rules of this particular tribunal on the interpretation of Section 20. They have no right to alleviate from Section 20, Your Honour. It's quite clear. It's written by Parliament, damage is damage. This adjudicator tried to call it ordinary wear and tear. It wasn't. It was caused by an accident through the carelessness or recklessness of this gentleman or whoever was operating the vehicle at the time. And I don't want to go on about the Wright versus Fortis, but this particular vehicle has been damaged. It's not ordinary wear and tear, it's damage. Now, I've got a very strong mechanical knowledge. We haven't taken the wheel off the car yet. Who's to say that he hasn't, by hitting a curb, caused more damage? We weren't allowed access to the vehicle, Your Honour.
Well, I take it you haven't refunded the purchase price.
Not at all.
And that Mr. Prersslip still has the vehicle.
I'm not sure, Your Honour.
Well, that's the order of the tribunal, isn't it?
It is, yes.
You repay the purchase price and he's to give you the vehicle back. You see, why does the right of rejection arise? There's something wrong with the vehicle.
If there is, Your Honour, we've repeated.
It's not supplied in a state that complies with the Consumer Guarantees Act.
That has been repaired, Your Honour. We complied with the CGA.
The tribunal didn't accept that, did it? Because it held that Mr. Prersslip was entitled to reject the vehicle because of the ongoing problems with it. You see, in theory, if there's nothing wrong with this vehicle, you get it back, you give Mr. Prersslip his purchase price back, you sell it again. Same price, maybe a bit more, you suffer no loss.
Sorry, Your Honour, my business, which I've been operating for 40 years, is going through the most significant downturn it ever has.
Well, that's not as a result of this vehicle.
Okay, and that's not the result of this vehicle, but if I can't rely on the courts to stick to legislation, I'll just simply wind that company up, Your Honour, and that's not a threat. But I've got pictures here of this car. You know, there's no way I'm giving this guy back his money. No way in the world am I giving this man who's acted in deceit back his money.
Oh, well, I mean, that's a matter for your decision, and I guess you'll have to accept the consequences of that.
Yes, I will, Your Honour.
You see, I would have thought that the word damage connotes some loss of value in whatever is damaged.
Your Honour, Mr. Prersslip, before this lawyer was involved, we had a Mr. Brett Cunningham involved for this appeal. Mr. Brett Cunningham invited us out to Arrow, Wills and Henderson. I'm not introducing new evidence, I was invited out there for this appeal. This lawyer is sitting on a report from Arrow, Wills and Henderson
We're getting into further
that
evidence.
will then show that this damage is more than minor. But notwithstanding that, if I can't rely on the provisos of the Consumer Guarantees Act, I can't run my business. And this vehicle's been damaged. I know you don't have to, you tell me you don't have to obey the evidence of what I've put in front of you, and I've had it reviewed by some fairly decent legal minds. It will just go on and on. It's legal aid, we'll be in the High Court, and I'm a dog with a bone. I just won't back off this because it's not fair.
Well, that's okay. I mean, that's your prerogative.
Thank you, Your Honour.
But what I'm trying to understand from you is whether you accept that even the slightest mark on a vehicle that can be, as I gave you the example earlier, just buffed and removed, it's gone.
Not buffed and removed, sir. It's an expensive piece of merchandise.
No, I'm giving you an example.
It's not a fair example.
If there's a scratch on it, that's damage according to you, is it not?
Well, I don't know. I don't make the law, but Section 20 tells me it's quite clearly damage, Your Honour. I take care in the presentation of my cars, and these cars are valuable. And, you know, it's unfair for these guys at the tribunal to make these orders. Does it give these people the right to appeal the decision on what might come out of this court today? I don't know, but there's damage on this vehicle.
Yes.
He's pushed us, this gentleman. He's abused us, he's abused my staff, he's pushed us. He wouldn't allow us back the car. We've since had the radiator check that he complained about, and that radiator hasn't even got a leak in it. Somebody put water in the system. He came back a day after he bought the car and wanted me to sell him an S500, which was reduced.
So, Mr. Murphy, this isn't helping the appeal.
All right.
I'm bound by what the tribunal says.
I mean, come on, Gary. Make up your frickin' mind. Is it
I'm bound by what the tribunal says.
you're bound by the tribunal? Or is it...
No, I'm not bound by that decision, am I? Decision of the Motor Vehicle Disputes Tribunal, or any of the other decisions of that tribunal for that matter. So the basic rule is that decisions of lower courts or tribunals don't bind courts of higher jurisdiction. It's a simple equation, essentially. The High Court binds this court, the Court of Appeal binds the High Court and this court, and so on.
Make up your mind, buddy.
I'm bound by what the tribunal says, right? And you say as a matter of law, the tribunal is wrong because you say the vehicle was damaged and therefore Mr. Prersslip had no right of rejection. So you say the tribunal was wrong to say that it was only minor damage, the sort of damage that might be caused by fair wear and tear, and therefore he did not lose his right of rejection. Well, that's the issue, isn't it?
It was an accident, Your Honour.
No, that's the issue.
That's correct.
Now, what I want to understand is what you say the meaning of damage is, that word damage in section 21C. Don't help me up a photo. I want you to tell me what you say the word damage means
Damage in this instance, Your Honour, is
section.
when a wheel of a vehicle crunches a curb in Auckland City, scuffs it significantly, and pulls the front bumper off.
Well, that's still not helping me with interpreting that word damage in the section.
Damage is something that has occurred on the vehicle since he's purchased it and it's been in his possession.
Yes.
Not
To
caused
what
by
extent?
us and not caused by him.
Or what if somebody backs into it like the hapless lady? It wasn't her fault. And that
Well, it
earlier
wasn't.
decision that you referred
It
to.
wasn't Fortis's fault either, was it?
Well, but they've lost the right of rejection according to these earlier decisions, which you
Correct.
say should be applied here.
Which is what's come out of Parliament, Your Honour.
If your interpretation of that word damage means any damage, any untoward effect to the vehicle whatsoever, it's a very high standard. Slightest mark on it, according to your submission, right of rejection's gone.
We're not talking about a slight mark with this particular case.
No, I'm not talking about this case at the moment. I'm putting to you propositions for the interpretation of that word damage. And I've put it to you a number of times now as to whether you say that any damage whatsoever, however slight it might be, less than fair wear and tear even.
Let's get something squared away really simple. He's dancing around the head of a pin. He's trying to get John, who's a layman, who's not legally trained, to define the word damage that a judge of over 40 years experience still needs it explained to him. What you'll find interesting very soon is that he's about to ask the other lawyer, the other side, the counsel, for if they happen to have a definition of the word damage. And wouldn't you know it, it's almost as if they had a little chit-chat before the hearing. She happens to pull out the Oxford Dictionary's interpretation or a standard layperson's dictionary to show the definition of damage. That doesn't show the legal definition. The Butterworth's thing that I show you does. The facts of the matter are, he was in possession of the vehicle was clearly ridden up against a curbing or a concrete berm of some sort, it damaged the rim, it damaged the front guard and pulled it out, and it took chunks out of the tyre. By the photos. Why Gary is trying to get John to define the word damage is he's trying to make it that John is the one that has to understand what the interpretation is. Judge Harrison is bound by the Consumer Guarantees Act. It doesn't specify minor or any other type. It just says damage. Which can be interpreted as the slightest scratch. It doesn't matter. General wear and tear is not riding your car up onto grass spurges and damaging your wheels. See that recurring word, damage? I'll leave you back to it.
as to whether you say that any damage whatsoever, however slight it might be, less than fair wear and tear even, loses the right of rejection.
I appraise cars. That's my job.
Still not answering my
go around them
proposition.
and I look for damage. And I look for money that needs to be spent on a car. I've done it for 40 years, so I'm fairly much an expert at it. And, you know, your or another person's idea of damage might be a bit flippant. They may not want to wash their car every week. They may not love it. They may not care for it like I do. For me to get the right price for these cars and to keep them selling, they've got to be perfect, Your Honour. They've got to be absolutely immaculate. Not like that. You know, that's totally unacceptable. That's accident damage, and that is why we're protected under the Consumer Guarantees Act. For these people that gain legal aid and just keep trying. Now, I don't want to annoy the court here today.
Well, if you could just address my question, Mr. Murphy, that would help. Do you say that that word damage means any damage whatsoever to the slightest degree that can be easily repaired? Do you say that costs the purchaser the right of rejection?
Well, if you look at the Wright and Fortis case, yes, I do, Your Honour.
Say the slightest damage will lose the right of rejection.
It's very hard for you to use this word slightest of damage, Your Honour, with respect, because what is the slightest of damage?
Well, I gave you an example a while ago of just some tiny scratch that can be easily fixed. It's a scratch, someone would say.
By painting the car?
No, you can just buff them out, as I understand it.
Buff them out with
polish them out, use some cutting application.
Once
I've done
again,
it myself.
with respect, Your Honour, I don't want to repeat myself, but the only way to fix a scratch is to send it in and have it painted by a quality painter. In this particular case, a Mercedes-Benz, where it's got to be painted in a 2-pack machine, and that's going to cost you around $500 per guard, $700 per bonnet. You know, what you consider, or some people consider to be minor damage on a cheaper sort of vehicle, if it can go to, and be cut and pencil touched like you say, it never looks the same. The folk that buy these cars are covered under the Consumer Guarantees Act. They're very particular, and rightly so too. Now, with a Mercedes-Benz or a Jaguar, a little scratch is going to cost you so much more to repair than if it was a Toyota Corolla, or if it was a vehicle that was painted in lacquer. These cars here are painted in 2-pack. There's no simple way of cutting and polishing with the type of paint that's on them, Your Honour. I'm happy to call Peter Hendricks and get him on the phone and he can explain it to you in professional terms.
I've already said to you that I can only take into account the facts as found by the tribunal.
But to say that minor damage, it needs to be protected from the retailer, and it is a car, but some cars are so much more expensive to fix than others. And to say it's just got a minor scratch on a Mercedes-Benz is totally unfair. Totally unfair. It's not a minor damage, but I'll get to that on appeal if I must. But the car, to repair these vehicles, both to service them and both to repair the damage on them, on the body, etc., is significantly more than if it was a cheaper car. Now, my yard in Green Lane has been there for 40 years, and we pride ourselves on selling approximately 20 to 25 cars a month, and quite a lot of those cars are budget cars. They're cars that are under $5,000. They would, if they were damaged, Your Honour, we would pencil touch them, and what we'd do is we'd brass sew the paint. We would then go to the paint shop and we'd get some paint to match it. If it was a white car or if it was a red car. Now what we're talking about here is a platinum black Mercedes-Benz that's painted in 2-pack. It's a procedure which means that it's got to be completely masked and it's got to be put in a bake machine. So yes, a minor scratch on this particular type of vehicle is considered to be damage. Likewise, if they have a stone in the windscreen, it's damage. I can then go back to not me, but what the reasonable consumer would expect of a big chunk out of the wheel of his Mercedes-Benz when I think to resell it again. I can assure you, Your Honour, that we will not be selling it for a lot more money or any more money like you suggested. In this particular market, I'd say we'd be selling it for $5,000 less.
Oh, well, I don't know, Mr.
Okay,
Murphy.
so why would I want to drag these cars halfway around the world, repair the defects from this particular gentleman? Both myself and staff take nothing but abuse from the guy, threats of suing, etc., etc., and then drag me through this court at the taxpayer's expense, and then find out that he's trying to argue over damage. Well, with respect, Your Honour, I know you've got to get to the bottom of all this, but it's fair dinkum. Like, he's lost. It's Section 20. It's there to protect me.
All right. Well,
I'm sorry, but it's the way I feel, and I feel very strongly about it.
well, I understand your position.
Yeah.
So you just say that the tribunal got it wrong because
Yeah, and I don't want to be horrible.
any damage whatsoever costs the right of rejection.
Well,
Okay?
we could argue this.
Well, no.
As an expert as I am with cars, I could argue it because I could simply say that, yes, if I had a Toyota Corolla on my car yard, and quite often the bumpers get scuffed in the corner, you can quite successfully cut them, brasso them, pencil touch them,
All right,
and then
well,
simonize them.
we've
Now, is that
discussed-
unreasonable to accept that that's not damage? I think that's acceptable in my view. But that's something we've got to argue on each individual case. Anyway, Your Honour, that's my position.
All right. Well, I understand that. You say the tribunal got it wrong because it misinterpreted
Oh, and we had a bit of a blue in there too.
Section 21C.
We had a bit of a professional disagreement in there, and you know, there probably was a bit of that going on. But you know, like I say, I have been in this business for 40 years, and I appraise. I work 7 days a week. I appraise every single car that comes onto my yard.
Okay, I understand that. You've told me that.
So I'm an expert.
Yep. I understand your position. All right. Thank you.
Thank you, Your Honour.
Ms. Fuyaba.
Sir. So the respondent's position is that the tribunal correctly assessed the minor damage.
Oh my God, now even Anna is admitting that the tribunal found that there was damage.
That the tribunal correctly assessed the minor damage.
Gary, go and ask old Andy Carter what his definition of damage is, because they found it too.
That the tribunal correctly assessed the minor damage of this vehicle as fair wear and tear, and that Mr. Prersslip did not lose his right to reject the vehicle. So it's Council's submission that this is a very narrow point on appeal, and our submissions will focus narrowly on this point. I would like to take Your Honour through the tribunal decision in some detail, sir, because that provides, in our submission, the context within which the adjudicator made its decision.
Well, there's no challenge to the finding that Mr. Prersslip had the right to reject the vehicle.
That's correct,
No
sir.
challenge to that. The only challenge is to the tribunal's finding that he had lost the right to reject it.
That's correct, sir. As you please, I can move forward then.
Yes. Yes, thank you.
So the key finding of the adjudicator was at paragraph 48 of the decision, which is at tab 5 of the bundle of documents at page 45, sir. In paragraph 48, it says there, Mr. Prersslip accepted that he has caused a small scrape to the left front wheel, and as a result of contact with the curb while parking the vehicle.
And there you have Mr. Prersslip, the guy himself, the guy who was in possession of the vehicle, admitting he damaged it. Admitting through his negligence and through his actions, he damaged the vehicle. Why are we even at the appeal?
There, Mr. Prersslip accepted that he has caused a small scrape to the left front wheel, and as a result of contact with the curb while parking the vehicle. After the tribunal requested him to do so, Mr. Prersslip provided photos showing minor damage to the front left tyre and a minor scrape to the wheel. Now, sir, I would like to take you to the photographs that I've also provided in the bundle of documents, sir, as this was evidence before the tribunal, and it is evidence that the adjudicator considered this matter very carefully before making its decision. So, sir...
Well, I can't do anything about it, can I, Miss Furiada? We just, after carefully reviewing the other photos Mr. Prersslip produced, we accept his evidence. There is, in fact, no damage to a particular area of the vehicle. After the PS para 48 that you've just read to me, after
yes.
the tribunal requested him to do so, Mr. Prersslip provided photos showing minor damage to the front left tyre and a minor scrape to the wheel. Except that the damage happened after he purchased the vehicle. Mr. Prersslip provided photos showing minor damage to the front left tyre and a minor scrape to the wheel. Except that the damage happened after he purchased the vehicle. But this is the crucial line. I am not satisfied that it is sufficient to amount to damage for the purposes of section 21C.
And that's where the tribunal was wrong. You've got the guy admitting he caused damage, even though he calls it minor. You've got photos showing damage from John, and yet they're showing photos that I would add have been photoshopped to the court to show minor damage. These photos were taken from a long distance. So you've got all of that evidence, them admitting they've damaged it after taking possession of the vehicle, him admitting that he caused the damage and his negligence. You've got Andrew Carter saying he doesn't believe it measures up to the definition of damage in the Consumer Guarantees Act. Well, there is no definition of damage. Damage is a loss of a value. It's that simple. You've caused damage to something you own, it loses its value. John cannot take it, put it back on the yard and sell it for the same price he sold it before. The guard was pulled off, all the rims are stuffed and the tyres, $500 tyre to change. But never mind, Gary just wants it gone.
But this is the crucial line. I am not satisfied that it is sufficient to amount to damage for the purposes of section 21C.
Yes, sir.
That's the line, isn't it?
It is, sir, and I will come to further discussion on that point, sir. My only, my point regarding the photographs, sir, is that there were 3 sets of photographs provided to the tribunal. The adjudicator considered them very carefully, and so it was a very considered and thought through decision when that finding of fact was made, sir, is my only point I'd like to point out there.
All right, yes.
Thank you, sir. Turning to the appeal itself then, sir, we note that appeals from the Motor Vehicle Disputes Tribunal are to be approached on the basis that they are an appeal from a specialist tribunal, and that the court in these instances will have an overall reluctance to interfere with the discretionary decision made by the tribunal. So Section 20 of the Consumer Guarantees Act is fairly straightforward. If the goods were damaged after delivery to the consumer for reasons not related to their state or condition at the time of supply, the customer loses its right to reject those goods. So I'm at my council's submissions at paragraph 25 now. So.
Yes, thank you.
So turning to the particular point Your Honour has identified regarding the damage as against ordinary wear and tear, there's council's submission that in this case the tribunal has made a proper distinction between damage that would qualify pursuant to section 21C of the Act and ordinary wear and tear. Included in paragraph 26 of my submissions now, so included in the tribunal's assessment is the cost of any repairs and type of vehicle, including its age and mileage. This is my submission indicates there is a threshold for the damage to be considered sufficient in order that a purchaser may lose the right to reject the vehicle. And this is to be distinguished from ordinary wear and tear. So Your Honour was seeking a definition of the word damage from Mr. Murphy, sir. The Oxford Language Dictionary states damage is physical harm that impairs the usefulness or normal function of something. So that's not in my submission, sir.
Now, Anna, that's not all the Oxford Language Dictionary or English Dictionary says, is it? Because that was the noun definition. The verb definition, in other words, the action word, which is what he did, he's not describing a noun. The verb definition is inflict physical harm on something so as to impair its value, usefulness, or normal function. Do you think tyres and rims are damaged? Back to it.
I can repeat that, sir, if you would like.
All right, I've got access to
Very
the
well,
Oxford Dictionary, so I can have a look at it.
So it's council's submission that that definition ties in with the distinction between wear and tear, ordinary, fair or normal wear and tear, and damage. It is noted that the tribunal also relied on the expert assessor, Mr. Gregory, in coming to this conclusion. And so we're at the decision now, which is back to tab 5 of the bundle at paragraph 50. So we're still on page 45, sir, of the bundle of documents. And there the adjudicator, paragraph 50, states, overall in Mr. Gregory's view, there was no damage to the vehicle that required any repairs apart from the ordinary wear and tear damage to which I have referred to earlier. I accept Mr. Gregory's assessment of this matter. So that's evidence that an experienced adjudicator, along with the expert assessor, has considered this issue and made that assessment. So I have to say, in my research and preparing for this case, I could not find any district court authority dealing with this point. Only further decisions of the Motor Vehicle Disputes Tribunal, which you've rightly pointed out are not necessarily binding on this court. However, there are some other decisions of that tribunal that seem to refer to a distinction, or appear to refer to a distinction between ordinary wear and tear and damage for the purposes of section 21C of the Act. In these cases, I've included copies in the bundle of documents at tab 11 and 12, sir. They actually happen to both be cases from the same adjudicator, Sir Carter. In these cases, both, in fact, these purchasers did lose the right to reject the vehicle, sir. But in both these cases, the damage was fairly significant. Paragraph 29 of my submissions, in Singh and and Spot 1 Limited, the tribunal found that the vehicle had damage to its front bumper that was not present when it was sold to Mr. Singh. In this case, there was evidence showing significant scratching to the lower part of the front bumper and a 3 to 4 centimetre tear to the lower right of the bumper. I'll just turn to the bundle of documents, tab 11, sir. Page 96. That's paragraph 24 there. In this case, the adjudicator said, oh sorry, wrong paragraph, we are at now. Page 97, sir, apologies. Paragraph 29. On the basis of the photographs of the damage to the vehicle and the estimated cost of repair, I am satisfied that damage exceeds the normal wear and tear that one would expect to see on a vehicle of this age and mileage, and consequently, Mr. Singh has lost the right to reject the vehicle. So, in the case of facia being advantaged cars, the tribunal accepted evidence of a scrape and a dent to the left side of the vehicle about 10 centimetres by 10 centimetres in size. Again, in that case, the tribunal concluded because the damage. So this is now at tab 12 of the bundle of documents, page 107. At the bottom there. That last paragraph, 47, sir. That is because the damage is more than the usual wear and tear that one would expect to arise from the ordinary use of the vehicle. It goes on to say, and although the damage may have been repaired easily and cheaply, it was nonetheless damaged. So, sir, these cases demonstrate the tribunal clearly conducts an assessment in relation to the damage for the purposes of section 21C of the Act. And the damage must reach a threshold beyond ordinary, usual, or normal wear and tear. It is submitted that Parliament must have intended to provide some allowance for fair wear and tear that would be expected to arise from ordinary use of the vehicle. Otherwise, this would produce an unjust result, and the proportionality of the wear and tear is considered against the value of the car or the other remedies available to the purchaser. In order for a purchaser to be entitled to reject under the Act, several steps must be satisfied. The opportunity to repair must be provided, and this must have failed, or alternatively, the failure must be of a substantial character. In Mr. Prersslip's case, both were satisfied, sir. To satisfy these steps and then be unable to reject the vehicle in the event where there was evidence of fair wear and tear cannot be the intention of the legislation enacted to protect the consumer. It is Council's submission that the tribunal in this case has made an assessment of the small scrape to the front left tyre and wheel and considered it no more than ordinary wear and tear, which would be considered to arise in the ordinary course of using the vehicle. The tribunal is very experienced in assessing these matters. It is submitted the court should be slow to interfere with the adjudicator and specialist assessor's decision in this case, and it was open to that tribunal to assess that Mr. Prersslip had not lost his right to reject the vehicle. Council seeks that the court confirm the common sense interpretation of the Act, that there must be some discretion in the assessment of damage in the context of a consumer losing their right to reject the goods. Your Honour, unless you have any further questions, I'll leave you with this.
Well, no, Ms. Fuyava, thank you. Now, Mr. Murphy, do you want to reply to Ms. Fuyava's submissions?
Yes, we need to. I'm just trying to get my head around this, Your Honour. I think it's important that we distinguish the difference between ordinary wear and tear to an accident or damage caused by the carelessness or negligence of the operator of the vehicle at the time. Now, I've seen this so-called tyre, which is expensive tyre to replace. If I was to go to NZTA in Sylvia Park, where I get my warrant of fitnesses from, and put the car through and say, well, the courts tell me that this tyre's okay, it's in keeping with ordinary wear and tear, they'd just turn around to me and they'd say, Mr. Murphy, that's damage. What are you up to? This is a safety issue here. My point, Your Honour, and I understand we're busy, we've got to get on with our lives, but this is not ordinary wear and tear. The adjudicator, unfortunately, may have got it wrong. This is damage caused by an accident attributed by the owner's carelessness or recklessness, which in my view disqualifies any entitlement to reject the vehicle. And with respect to my learned friend here, the cases at Advantage Cars that she mentioned, you know, we're talking about a 3mm scratch. Well, I go back to my earlier submissions. Every car is appraised differently for the price it's sold for, type of vehicle it is, and what we'd expect the normal consumer to expect. This is a Mercedes-Benz which requires specialist paint finish and specialist panel beating. The tyre itself, well, they are $450 new to replace. So that alone would prove that it's not a minor accident, but then again, being the vendor, a minor damage, you know, to me, you know, is fairly serious, and that's why the provisos made by Parliament in the Act are there, in my view, Your Honour. I don't want you jumping over the portal at me, you know, I'm just trying to be reasonable. And being experienced in 40 years in this business, I spend tens of thousands of dollars extra in sorting these problems out. And this is one that we've dug in on, and we've got one other on at the moment that we're digging in on. I try and do the commercial right thing in these instances, but sometimes these people just won't leave you alone. We haven't got all day to explain the ins and outs of this case, but I'm saying, Your Honour, I consider that this is damage caused by an accident. It's not normal wear and tear, and it is a damage which is probably a bit more than a scratch. The tyre cost alone is significant. That is my submission, Your Honour.
All right, well, thank you. Well, I'll reserve my decision. I want to read these authorities in more detail, having heard from you. So thank you both, and Ms. Fuyava particularly, for getting these decisions together. So I'll let you have my decision just as soon as I can. All right, thank you.
This court is adjourned. All stand.